Joining us today are two guests with deep expertise in international law, but very different perspectives on this issue. Andreas Motzfeldt Kravik is Deputy Foreign Minister of Norway. He's a lawyer by training and has worked extensively on international law within the Norwegian government. Natasha Hausdorff is an expert in international law and law of armed conflict, a British barrister and legal director of UK Lawyers for Israel Charitable Trust, and she's a frequent commentator on the legal aspects of the Israeli-Palestinian conflict. Welcome to the both of you.
Thank you.
Thank you.
Before we begin the debate, here's a quick overview of what this is about. In June 2026, the Norwegian government published a draft law for public consultation. The proposal will make it illegal for Norwegian citizens and companies to trade with Israeli settlements in the West Bank and East Jerusalem. Specifically, it would ban the import of goods produced in those settlements, the export of goods to them, the purchase of real estate there, and related services such as construction or properties transactions. The government argues that the settlements are legal under international law and that Norway should not allow its citizens or businesses to support or profit from them with infractions potentially resulting in fines or up to 3 years of imprisonment. The proposal also makes attempting and complicity punishable. Because many of the prohibited acts would take place outside Norway in the settlements, the ordinary requirement of dual criminality is waived. The consultation period runs until mid-September, after which the government will decide whether to send a final bill to Parliament. That is the proposal we will be discussing today. So let's start with just a few questions about the fundamentals before we get into the practical end of things, because it's easy to get stuck on the fundamentals, but we just have to address it with one question. So Natasha, is the West Bank, including East Jerusalem, occupied Palestinian territory under international law in a way that makes Israeli civilian settlements there illegal, or is its status disputed?
So certainly I would prefer the term disputed territories because the proper application of international law does not lead to the conclusion that you've set out. The key argument that is frequently advanced, and indeed has been with respect to many of these trade ban proposals, concerns a prohibition on state transfer of its own civilian population under Article 49.6 of the Fourth Geneva Convention in the context of occupied territory. There are multiple problems with that here. We're not talking about the state transfer of a population. We're talking about individuals moving to this territory of their own free will as an expression of their choice. And we are not talking about them moving into occupied territory, properly analysed. The borders of the State of Israel under the customary rule of uti possidetis juris are clear from 1948, and they include East Jerusalem or Judea and Samaria, which is what this territory was referred to before Jordan's occupation, and also, for that matter, Gaza. But those were all territories that were occupied by hostile states that declared war on the fledgling State of Israel in 1948. And this is the very same territory that Israel then recovered in 1967. So in a nutshell, it is impossible to occupy what was already your own sovereign territory. And international agreements underscore this point. The armistice agreements between Egypt and Jordan and Israel all refer back to the mandatory lines. Those are the borders that Israel inherited upon its declaration of independence, as do the peace agreements. And of course, since then, since Israel's recovery of this territory in 1967, we've had the Oslo Accords with international endorsement, which endorsed Israel's continued civil administration of areas that are concerned here with respect to these proposals, areas of Jewish settlement, Israeli control that are indeed infrequently referred to as illegal settlements, but that is frankly on a misstatement of international law, both with regard to the status of the territory and this misinterpretation of Article 49 of the Geneva Conventions. The fourth one, I just finally say, the irony of the misapplication of Article 49 cannot be overstated. This was a provision that was drafted in response to the Jewish experience in the Holocaust of being forcibly transferred by the Nazis to extermination camps, concentration camps, forced labor camps. The notion that this would now be wrongly deployed in this fashion to justify a position that Jews should not live in certain areas just because they are Jews is pretty affronting. I think it's morally repugnant. And what we've seen, which we'll come on to discuss, of course, in relation to these trade ban proposals, is this continuation of this notion that this area should be free of Jews, Judenrein. And that takes us back, unfortunately, to those Nazi practices.
And Andreas, your comments to this and your perspectives on this question.
Yeah, thank you, and thanks very much for hosting us on your podcast. And I think it's good that we can have a discussion about the fundamentals because I think obviously our approach to trade ban very much hinges on whether or not these settlements are legal or illegal. And for us, this is a pretty straightforward question to respond to. In fact, this is now for most states settled law. The ICJ has clarified most recently in its advisory opinion that the settlements are not just illegal. Israel has an obligation to dismantle the settlements, to pull out of the West Bank and East Jerusalem and also Gaza. And this is not only confirmed by the ICJ, the International Court of Justice, in a unanimous decision, save for one justice who took this viewpoint, but this is also the majority position or almost a unanimous position by all states, certainly all European states, the United Kingdom, France, Germany, Italy, Australia, Canada, even for the most part, the United States have all taken the position that these settlements are illegal. And we can get into the law, and I'm happy to discuss some of the points that Natasha raised. But these submissions were all put forward to the International Court of Justice, and they were rebuffed. So this is not a marginal topic. This is not something which is difficult. This has been resolved. And for Norway and the Norwegian government, obviously, we will have to look at this on the basis of what the International Court has said, on the basis of what most other countries and governments are saying. And also, this is our determination. This is not about making certain areas Juden-free and these sort of racist terms. This is one country occupying another country, and Norway has always been on the front line of opposing occupation. We have taken the same position as regards Russia and Ukraine. Russia has tried, and we have discussed it previously, Henrik. Russia has now tried to occupy and domesticate certain provinces of Ukraine, making them Russian. And we have been very clear about that. That's illegal under international law. And we're taking the exact same position on these settlements. And one thing is the settlements, they're obviously very legal. And as I said, most countries also outside of Europe would say the same thing. But when you look at what's happening within the settlements, the repression against Palestinians, the evictions of houses, the demolition of houses, these are actions that have to be rebuffed, have to be counteracted, and that's what we're doing with this law. And I should underline that this is a law which is subject to review, so we'll see what happens on the other side of that process. But for us, obviously, since we have made it clear that international law will be front and center of our foreign policy, we have an obligation also towards ourselves to be clear-eyed about what's happening on the West Bank and in East Jerusalem and Gaza. These are illegal settlements, again, confirmed by the ICJ, confirmed by most states, also the Security Council, and we will do everything we can to push back on these developments.
May I ask one
Natasha.
question? Yes. Who is it occupied from? You say this is one country occupying another country.
So they're a Palestinian territory. That's straightforward.
But that's never been a country, and that's never been Palestinian territory. There is
How many?
phenomenon. Yeah, there is a phenomenon here which is very worrying, which is that international law buzzwords are being used, contrary to what international law actually says, to promote a particular agenda. And, what is the dismantling of Jewish communities here other than ethnically cleansing Jews from this territory? The fact that the International Court of Justice has, as you have indicated, said that it will require or request or wants to see the ethnic cleansing of Jews from this space doesn't make that in any way morally or legally acceptable. And you and I both know that an International Court of Justice advisory opinion is not binding in any way. It does not create international law obligations. It absolutely did continue to promote this sort of position, everybody says, which you yourself have referred to. This is settled and lots of countries take this position. That doesn't make it right in international law, and it doesn't create an international law binding obligation. which you indeed should know as a lawyer, what we've seen is the continual misstatement of both the facts and the law. And this comes to the sort of violence that you've referred to. A lot of this, of course, is being promoted by a lot of the media misinformation here. But when we look at some of the reports that even the ministry has relied upon in relation to the consultation paper with respect to this trade ban, we can see its very strict reliance on UN reports, statistics, figures. And it's important to qualify that because in relation to the violence that you've referred to, the United Nations itself has put out data that considers an elementary school class visiting the ancient site of Shiloh to be settler violence. It considers escorted visits of Jews onto the Temple Mount to be settler violence. This is not just an inversion of international law or a disapplication of it or even double standards when we consider real situations of occupation around the world, real situations of, if you will, illegal settlements that are never picked upon, that are never called illegal, and that are never subject to these sorts of proposals on trade and sanctions. But even before we get to that, the misinformation that is put out at a very basic level in order to justify this position that Jews should be expelled from these areas is morally reprehensible. And quite apart from that, it is providing an unsound basis for the pseudo-legal analysis which follows, which this consultation paper is rife with, which could put Norway in a very difficult position vis-a-vis the real obligations that it is subject to in terms of its trade relationship with Israel, in terms of its responsibilities under the WTO, in terms of US sanctions and legislation in relation to boycott of Israeli businesses operating in Israeli-administered territories. So in respect of all of those, this is a proposal, a position that is seeking, I don't quite understand it, to ignore the realities of the law and the facts on the ground, and potentially put the Norwegian government in breach of what real international law says.
Andreas?
Well, I think it's fascinating to claim that you have the right and a deep insight as to what the international parameters represent here, given the fact that most countries, if not all countries, take the same position as ours in respect to these settlements. I'm happy to have a discussion about whether or not a trade ban is a smart policy in order to push back on these developments. That's a discussion I think is warranted, merited, and some countries have chosen a different approach. Again, fine, we can have that discussion. But I think, and that's why I was complimenting Henrik at the top here for discussing this particular topic, because I think it's important for our viewers and listeners to understand that what you are putting forward as a legal position are not shared by anyone. There's not a single state beyond Israel who's taking that position. And these arguments that you're putting forward, that this is not an illegal occupation, has been tried and tested. It has been put before various tribunals. It has always been contested and rebuffed at the end. It has been litigated before various country parliaments in countries, various cabinets, various governments, always rebuffed. And even the United States, for the most part, have claimed that these settlements are not in line with international law. I think the term has been usually inconsistent with international law. And again, this is the position of the Norwegian government. I don't think that you'll find, and I know this is a domestic argument, but I don't think that you'll find one singular Norwegian political party, at least not represented in parliament, who take the position that you are now advocating.
But I
All
want to
the
make a clear
Norwegian
distinction.
politicians would claim, will claim that these settlements are illegal. And you're right. Obviously, we're basing ourselves on data, empirical data by the United Nations, but not only the United Nations, also organizations within Israel who are reporting on these violations by settlers, house demolitions, evictions by Palestinians. And this is something that obviously is underpinning the proposed ban. And just to say, we're not advocating for boycotting Israel. In fact, this is not in line with Norwegian foreign policy. We've said one of our top concerns is Israeli security. We want to see a two-state solution. We support Israeli sovereignty. We support Israel's right to exist. In fact, we have historically we've had an excellent relationship with the Israeli citizens, the Israeli community in Israel, and we want to support. In fact, we want more trade with Israel. The Norwegian Sovereign Wealth Fund is heavily invested in Israel, and that's something that we can support. But we will not support this kind of behavior, which is obviously illegal and obviously analogous to what we're seeing conducted and perpetrated by other countries, not least Russia. So on
Right.
this,
Can I pick up
I'm
on that
happy
point in
to
particular?
disagree with your position. And again, I think my position is represented or aligned with almost all serious countries on this issue.
So I want to
Natasha?
make a clear distinction between the political rhetoric, which you're advancing in order to justify your position, and what international law
No,
actually
no, but
says.
I want
Because,
to intervene on that because that's
yeah,
this is based on a uh, legal analysis, and
well,
I hear you keep coming back
can
to
I just
political
drill
rhetoric.
down on that?
Let me just outline our argument, and then you can under
Just before you outline your
international
argument,
law.
may I just
Yeah,
pick up the example of
Natasha.
Russia? Because
Yeah.
my
All right.
position is that the analysis so far that you've put forward
Mhm.
is incoherent. You use the
Okay.
example of Russia occupying parts of Ukraine
Mhm.
and said that you were being consistent in your
Right.
analysis, but you're doing the complete inverse of that. Because the reason there is international consensus that Russia has occupied Crimea from Ukraine is because Ukraine's borders also followed uti possidetis juris. Answer me this, and then please set out the rest of your legal position. If Ukraine were to recover Crimea from Russia, in the same way that Israel recovered Judea and Samaria and East Jerusalem from the Jordanians who had occupied it between 1949 and 1967, would you accuse Ukraine of occupying Crimea from Russia? And if not, why the double standard for Israel?
But there is first and foremost, I'm not sure who's asking the questions here, but that's an obvious misstatement, or at least it's not. It's a logical fallacy. Obviously, as you said, there's an international consensus, at least something that borders on an international consensus that Russia has occupied and is trying to annex part of Ukraine. I agree, but there's just to be clear about this, the international consensus that Israel is occupying the West Bank, Gaza, and East Jerusalem is equally robust or even stronger. So I just want to put that, but
But it's based on the
I'm sure
opposite
you will characterize it.
application.
Well, let me respond. You asked the question, and I'll respond to it. But I just want to say, in terms of the politics surrounding this discussion, there is no distinction to be made between Russia and Israel in terms of who's occupying who. So that's clear. There's an international consensus on both. Now, in terms of your example, I think it's a very good example. You're entirely right. If Ukraine were to recover Crimea, obviously we would recognize that as Ukrainian territory. Same thing with Israel and Palestine. Now, your example only works if, let's say, Palestine were to regain sovereignty over the West Bank,
When
and then
was Palestine ever
hang on, let
sovereign?
me just finish, and then you can
But
comment.
you,
And then
you,
Israel reoccupied it, then that's the example. Then we wouldn't say, oh, you're reoccupying it, so we're gonna recognize that as Israeli territory. It doesn't work. This is by various Security Council resolutions, by various decisions by the ICJ. This is Palestinian territory, and this is not about Juden-free or about ethnic cleansing and anything of the sort. This is about making it clear that one state cannot occupy another state's territory. This is straightforward. And the ICJ has gone further. It has not only said that the occupation is illegal, it has said because of the repeated and multiple violations of the law, Israel has to dismantle these settlements. And this is quite clear why this is being said, because again, an occupation can be legal. I'll grant you that point. Under international law, an occupation can be legal, but obviously inherent in the topic of occupation is the term temporary. But there's nothing temporary about this. In fact,
because
it's
it's not
been
an
made
occupation.
structural. But my point. It seems to me that you're not labeling this as a temporary occupation. It seems that you think that this is Israeli territory. You think that
Well,
Israel...
that's what international law says.
Right.
The same
Okay. So this
international
is
law
not
that you
just
would
a
apply to
minority
Ukraine.
position. This is a minority of a minority position. One
I'm
thing
simply
some scholars will say that the West Bank and Gaza are occupied, but the occupation is legal under the Geneva Convention because the state can, in the interim, can occupy another state's territory. Fine. Some will say
I
that
mean, what other
we're not
scholars
in
may
that
argue is
category. But
irrelevant to the
very few
discussion we're
scholars, in
having.
fact, you're one of the first one I am encountering, are saying that this
I'm certainly not.
territory belongs to Israel.
But
Which
now
goes
Natasha
against
has
a
to
number of Security
respond.
Council resolutions, a number of General Assembly resolutions. There's no support in jurisprudence by the International Court of Justice. It's not a position that is tenable.
Deputy
Yes,
Minister, you do
Natasha.
appreciate that the UN doesn't create states. The UN doesn't give states territory. The UN doesn't,
The UN doesn't create states.
Of
Is
course
that your
not.
position?
Of course it doesn't create states.
Uh,
The UN doesn't have any power of that nature.
So the
This is
Security
pretty
Council can't
basic.
talk about sovereignty?
Well, certainly we've not had a single Security Council resolution here with any binding effect. These are political declarations under Chapter 6 of the UN
Because
Charter.
I think this is a very important point. Just to interject briefly, are you saying that the Security Council of the UN cannot create international legal obligations?
I didn't say that. There's a very narrow power for them to do so under Chapter 7 in very narrow
That's a narrow
circumstances.
power.
And they've never done that in relation to Israel. That's to be sure. What you're referring to, and this comes to the crux of the matter, are political resolutions and political rhetoric and bluster. I mean, quite apart from the fact that the advisory opinion of 2024 is not legally binding, it's also woeful in its application of the law and the facts. And the absence of proper fact-finding there renders the conclusions that it reaches, albeit them not binding, rather unhelpful in this respect. What I'm talking about is a return to actual international law. And what I'm really concerned about is that in addition to these misrepresentations of international law, we're getting a rewriting of history. The notion that there was a Palestinian state, that it had its land taken away, that it would recover that territory. This is a very basic misrepresentation of the historical narrative, let alone the legal frameworks that therefore apply. And so if you're getting the first one wrong, one doesn't have much hope on the proper application of the latter, that the combination or the comparison with Ukraine here is pretty stark. And the fact that, it's not just you, of course, Deputy Minister, I don't want to make this overly personal, but the fact that there are even lawyers out there that would seek to make that argument, that on the one hand, they would say Ukraine has sovereign title to Crimea, and on the other say that Israel has no sovereign title nor claim to these disputed territories, in particular East Jerusalem and Judea and Samaria, is worse than double standards. It is a misapplication of international law in the extreme, which I would argue renders the international legal order itself at threat. Because, if everybody says is how we're now judging international legal situations, the international legal order ultimately loses credibility.
Yeah. Well, can I just briefly intervene and say, I think that the fact that you're referring to these areas as Judea and Samaria sort of gives away the game. You think that this belongs to Israel. You think that this is a place where Israel can or Israelis can settle based on their own will. Again, that's a position taken by no serious government. In fact, I can't, beyond Israel, I don't think that there is a single government who's taking this position. But be that as it may, I think what's important for me and for us is to just state unequivocally that our position is aligned with most governments, aligned with the International Court of Justice, aligned with almost all decisions taken by various international entities, that these are illegal settlements and they should be rebuffed. They should not be recognized by sovereign states. So we will certainly not recognize these as settlers belonging to Israel. In fact, we will do the opposite. We will do everything we can to ensure that they will not thrive, that they are undermined, and that Palestine can control their own territory, just as Israel can control its territory. This is our approach to international law, and that's shared by most people.
Respond to this.
But I just want to add one more point.
Just a question before you do.
I just want to add one more point, and then I'll turn the floor over to either Henrik or Natasha, whoever wants to take it forward. If you were to apply your own logic, that this is in fact Israeli territory, that Israel has sovereignty over these territories, over the West Bank, Gaza, and Eastern Jerusalem, I think even then, obviously we don't agree with this, no country does. But even if you were to apply that logic, the way in which Palestinians are treated goes against all of the basic tenets of international law. They have no right to
Okay,
vote.
well,
They
just
have no
on
right
that
to
last allegation on
protection for
Palestinian
basic human rights. No right They have a distinctly separate system under their criminal code.
I'm sorry, that's simply
If Israel was serious about this proposition, that look, this is one territory. We're going to govern this as there's one state. Obviously, you'd see a different treatment given that Israel is claiming itself to be a democracy that aligns itself with international legal obligations and human rights. So either you are resorting to the law of occupation, implicitly admitting that this is an occupation which has to at some point stop, or you're saying that no, there's no occupation. This is just Israel's sovereign territory, and we will control this as we control other parts of Israeli territory. Obviously, then grant all individuals on that territory the same rights as we grant other individuals. But you're sort of doing both. You're saying on the one hand that it's occupied, and you're saying on the other hand that it's not
never said it was
occupied. That
occupied.
it's
No,
Israeli
forgive
territory.
me. Now you're putting words in my mouth. There's a very simple answer to the conundrum that you are struggling with, and that's the Oslo Accords. Because since the 1990s, there has been a very clear administrative framework whereby these territories have been administered, whereby Palestinians have self-determination under the Palestinian Authority in the Palestinian autonomy in areas A and B. And these, bizarre notions and broad sweeping allegations of the way that Palestinians are treated are simply incompatible with the facts. I'm just looking here at measures in East Jerusalem that the ICJ claimed was creating an inhospitable environment for Palestinians. But according to a Palestinian news agency poll, 93% of Arab residents of East Jerusalem preferred a continuation of Israeli rule in the United City, and Israel Central Bureau of Statistics found that 86% of Arab residents of Jerusalem are satisfied with their lives. That's also consistent with the movements of people that I very simply referred to a poll by a Palestinian news agency that found that 93% of Arab residents of East Jerusalem could prefer a continuation of Israeli rule. Also a survey by Israel Central Bureau of Statistics that 86% of Arab residents of East Jerusalem are satisfied with their lives. That is simply inconsistent with the broad brush sweeping statements that you have made. And before that quotation, I explained that the answer to the conundrum that you are struggling with is the Oslo Accords. I don't understand why you, Norway, many other states would see fit to throw that international agreement out of the window. Article 17 of Oslo II expressly excluded Palestinian jurisdiction from these territories. It specifically in relation to the trade aspects of this, which I still hope we'll have time to come on to, talked about the customs union in which Israel administers external customs, the border of the entire envelope. So the fact of the matter is that Oslo itself recognized Israeli administration in the areas in which these businesses are operating. It's an important side point, of course, that everything you've discussed up until now is entirely academic when we actually come to discuss the parameters of the trade ban, because you're talking about private businesses operating in these territories.
Can I
Nothing
just
to do
respond
with
briefly?
Norwegian to Israeli trade. You've covered so many areas.
Do you
I
think
know we're
most
short on time. Yes?
do you think most Palestinians on the West Bank and in Gaza are satisfied with their lives?
Israel doesn't govern them. Those that Israel does
Israel doesn't
govern,
govern the West Bank?
I explained to you, those in East Jerusalem that Israel has given residency, and there's an option for them to apply also for citizenship.
But
That was what this poll referred to.
I just
I
need this
also
to be
explained,
clarified, if I could,
yeah,
because I think again, most countries who take a different position, or not countries, because I don't think that there are that many countries. In fact, there are 0 countries that I can think of who take a different position on us in terms of the legality of the settlements. But there are some scholars, not very many, but there are some, and they'll typically say that the occupation is legal. There might be some problems in terms of how it's implemented. They'll grant that there's settler violence and that maybe there's a lack of
it's irrelevant to
accountability.
the discussion
But
we're
I'm just
having.
I just want to push you on this so I can get clarity. And I think this is important also for the viewers and listeners. Are you saying that there is an occupation, but the occupation is
I
legal?
don't know
Or are
how
you
I could
saying
have
that
been
there is no
clearer.
occupation?
I've said from the very beginning of this that the framework of occupation is entirely inapplicable where
Okay,
territory has
so
been
there's
recovered in
no
this
occupation.
instance.
Okay.
It doesn't work.
It doesn't work. All right. So I just want to say for the record, and this is important for the viewers and listeners, this is not a position which is taken seriously internationally. There is no government taking this position. There is no international court who has ever pronounced anything analogous to what you were
I
just
also
saying.
made that
So
clear
this
when I
very
said,
deep insight into how the law works is not shared by anyone.
but there's a difference
And
between
certainly not the
the
Norwegian government.
application.
We will take the position
Natasha has to
again that
respond
these
to that.
settlements are illegal. They are an impediment to the two-state solution, and we will do everything we can to ensure that they are not given legitimacy and that they are pushed back on. But having said that, and this is important for me also, we are not supportive of a boycott of Israel. I know that some have discussed internationally that there should be some sort of trade ban against Israel, that we shouldn't allow our companies and our enterprises and individuals to trade with Israelis. That is not the position of the Norwegian government. We're not supporting that at all. In fact, we want to have robust relations with Israel. I've visited Israel multiple times. We have historically a wonderful
Yeah.
relationship with
But
Israel and
Natasha has
Israelis,
to
and that's a
respond,
different
Andreas,
thing.
to that. And Natasha, about that.
I'm sorry, we're just back to this, fallback position of everybody says. Everybody says it's not international law.
It's
It
actually
is
pretty
not the
important.
equal. Am I?
Let Natasha,
It is
let
not.
Natasha
It is not
respond.
a reflection of what international law really says here, and we see that on the basis that in every other situation of real occupation, as envisaged by the Fourth Geneva Convention, and real transfer of individuals under Article 49.6 in Western Sahara, in Cambodia and Vietnam, in Northern Cyprus, certainly in Crimea, in Abkhazia in relation to Russian activities. In all of these instances, this argument is never put forward. So you cannot advance a credible analysis on international law when it only applies to the one Jewish state. I'm really conscious that the Deputy Minister doesn't have very much time because we started late. And I do feel the need to say, even if you ignore everything that we have previously discussed, and we'll work on the false position that there is some illegality here, nothing in international law justifies a trade ban, and we're talking about Jews in Jerusalem here. So the Deputy Minister can talk all he likes about wanting to foster a positive trading relationship with Israel. There is a discrimination at play here, which is unconscionable and illegal, and will put Norway in breach, not just of the agricultural agreement between the Kingdom of Norway and the State of Israel from 2021, but also the FTA between EFTA states and Israel from 1993, obligations that Norway has thereunder. We mentioned previously obligations under the World Trade Organization, the GATT, the General Agreement on Tariffs and Trade, the General Agreement on Trade and Services. I mentioned previously also US, state and federal laws that this would fall foul of. All also require the US to essentially consider and address this issue of boycotts against certain businesses operating in Israeli-administered territory when negotiating trade agreements. So Norway is going to be really harming itself vis-a-vis potential relationships with states. Quite apart from all of that, we're not dealing here with Norwegian to Israel state-to-state trade, which seems to be what the Deputy Minister and indeed the consultation agreement is driving at. We're dealing with private businesses that has no place in the analysis that we've heard so far. And then we move on to the actual international agreements that govern not just the administration of this territory, but also the application of trades and tariffs. And I've mentioned the Oslo Accords. We also have the Paris Protocol of 1994. And all of this has been endorsed by the international community and has been thrown out of the window. Now, I have to say, the ministry acknowledges a breach of WTO provisions. And I think it's also important in that respect to highlight Article 26(5)(a) of the GATT that talks about international responsibility for the territory. So it's important that these trade agreements all approach questions of sovereignty on territory neutrally. And they work according to who administers the trade area, who deals with tariffs and customs. And in every respect, and according to the Palestinian Authority itself, that's Israel. And most recently, in 2020, when the ICC asked President Mahmoud Abbas to confirm the status of the Oslo Accords, he said that they were still valid. So all of this makes very little sense to me. On the flip side, we've had these references to UN Security Council resolutions, which are political, not binding, not legal instruments. We've had references to advisory opinions of the ICJ, which are likewise not legally binding. But even if you ignore that, none of them create international law obligations. Norway's international law obligations under these trade provisions are clear. How on earth can you sell this proposal to the people of Norway when it puts them at such risk of these consequences when these obligations are breached?
Andreas?
Yeah, there was a lot of things there which doesn't align with our thinking around this. Obviously, otherwise we wouldn't have put it forward. But just for a start, our trading agreement with Israel from the 1990s obviously traces back to Israel pre-1967. Those are the borders which are recognized explicitly under the agreement, and that's been the case for decades. So that's number one. Number two,
that phraseology
you
doesn't
spoke for a long
appear.
time, Natasha, so it's important for me to be able to
But that's not accurate. That's not what the agreement says.
Okay.
Can you tell me where in the agreement it references that?
It is our free trade agreement with Israel only pertains to the pre-1967 borders. So that's
what
a settled law, and it's been the case for
Forgive me,
a long
on what
time.
Basis?
Secondly, when it comes to the
What does that
WTO,
mean?
it's false that we have recognized that this is a violation of the WTO. That's not in the consultation report. In fact, it says the opposite. We have looked at the rules under the GATT agreement, and for us, our interpretation is clear. Again, it aligns with most other countries. Israel we are not allowed under the WTO framework to discriminate between states. I'll grant you that point, but we are not under an obligation under the WTO to grant rights to occupying powers. And again, this is an occupied occupied territory. And this is our reading of the law, and this is the reading of the law which is shared by almost all other countries. And I just want to come back to this this notion that I'm referring back to what others are saying, and this is that everyone says, and that's sort of a simple argument. The reason why I'm saying this is not just simply to make it clear that the position being advocated by Natasha is a minority position. It's also not how international law works. Very clearly, when an international tribunal, for instance, is ascertaining a legal question, they will also assess what other governments are saying. So obviously, when the ICJ, as an example, looked at the settlements, they also looked at what other countries are opining on this. And again, when it's important for the readers and viewers, when listening to Natasha's arguments, to hear what she's saying about other entities. She's saying that countries should disregard binding Security Council resolutions. These are
they're not binding. I'm sorry. Which one?
She's saying
which one?
The governments should disregard the positions taken by the ICJ because these are non-binding, allegedly. She's saying that even if all governments are saying the same thing as we're saying, well, that should also not count. So, this is not how international law works. This is not how international politics work.
Exactly how
and I think it's clear that these are illegal settlements. And we have decided, because this has been a central part of Norwegian foreign policy to try to move us closer to the two-state solution, we will do everything we can to ensure that we do not facilitate these illegal actions perpetrated by Israel. And this
Natasha has to answer.
One facet of our foreign policy, and we're putting this forward. And I have to say, I think it's very clear now that in the next few months, and probably maybe some time, you'll see other countries aligning their policies with us. Already, you have seen the UK, Canada, Australia sanctioning Israeli cabinet members because of their advocacy and their actions in relation to these settlement activities. So countries
now,
that
Andreas,
take Israeli
we are running out of time,
seriously.
so Natasha has to answer. because we're so little on time. So Natasha just answered this, and I have to challenge Kravik on a couple of questions before we're running out of time.
Okay, well, we're coming back to this notion that I don't know another way of expressing this other than everybody says. What UN Security Council resolutions have opined on in relation to this, their political declarations. I'm not saying ignore them. I'm simply saying they're not in any way valid for the argument that you're putting forward, because they're political, not legal. If you look at what real international law says, not least in terms of the underlying legal frameworks, but also in terms of Norway's obligations under these trade obligations and trade agreements, then the Norwegians are going to be in trouble. I mean, I look at the seal products case, in which Norway actually argued exactly this point, that the EU import ban, which was being justified on public morals, was applied in a manner that constituted an arbitrary and unjustifiable discrimination against Norwegian sealers by comparison with Greenlandic indigenous hunts. So trying to have your cake and eat it doesn't quite do justice to the situation where we've got incoherence and inconsistency with respect to your policy, for example, vis-a-vis Crimea and Jewish communities in Judea and Samaria, or the West Bank, which is what the Jordanians called it while they were in occupation. We've got a complete incoherence in relation to how this will be justified under the existing trade relationships and agreements and actual international law obligations, which Norway has signed itself up to. And all of this then comes back down to this bizarre notion of everybody says, and saying, rather than grappling with the arguments that I've put forward, you tell me it's a minority view. Well, it may be, but that doesn't make it wrong if the analysis is sound.
Sure, I'm just saying that the probability of that analysis being sound when everyone takes a different viewpoint is not very great. But I have
tell
to
me
say
why
that
the analysis is
every
unsound.
time I say something, um, I do think it's important just to distinguish between saying everyone agrees with me and referring back to normative instruments which have real power under international law. I'm referring back to decisions and opinions by the ICJ, not marginal decisions by the ICJ, consensual decisions by the ICJ.
A majority
For
decision.
instance, the ICJ's latest decision from 2024, which was 14-1 on this. So this is a clear position taken by the ICJ. You have multiple resolutions by the Security Council. And again, you have various governments, all governments saying exactly the same thing. So this is, in our view, settled law. Now, I'll grant you that you can have a discussion about the practicality of this prohibition. Will it be significant? Will it work? These are the kinds of issues that we can discuss. But this is not, and I think you're referring to this, risking, is something that could risk us being characterized as being an international violation of some norms. This is now being subjected to consultations for some time. We haven't heard a single view taken by any government that this is wrongful, that this is a violation of a standard or a law or an instrument. In fact, we have very good relations with the United States. They know our position on this. So we're pretty confident that this will go forward. And if we decide to implement this on the basis of what the draft says, then it'll be implemented, it'll be followed up on. And again, I'm confident that there will be no repercussions, hopefully, and I think there's a good probability that other governments will follow us, just as other governments have followed us in terms of characterizing these settlements as legal, just in terms of other governments have followed us in terms of being very skeptical to what Israel is now currently doing on the Gaza Strip, and just
But
as other
Andreas,
governments are now condemning Israel for settler violence and
we're
for
running out of
increasing the
time,
number of settlements in
Andreas.
the West
I
Bank.
just have a few questions before running out of time. Andreas, Turkey occupies northern Cyprus, so why is there no Norwegian trade ban there?
Say it again, I couldn't hear you.
Turkey occupies northern Cyprus. Why is there no Norwegian trade ban there?
Well, we have been very clear about the northern Turkey. That's not something that we're recognizing, and we have also an advisory out that has also been applicable to northern Turkey, but that's not the occupation there cannot be analogized to what's happening on the West Bank with the settler violence, with the evictions, et cetera, et cetera. So we have decided to put this forward because we do think it's important to make it clear that these settlements in Israel, that Israel is organizing now and in Palestine are just not in line with international law.
Okay, we're not going to agree clearly on the implementation of this and the implications for Norway or the international law framework. What about the implications for the Arab-Palestinian local population that is employed in these businesses? I'm looking at figures that indicated in May 2025, 32,000 Palestinians were working in what you call Israeli settlements.
There's a carve out in the proposed legislation, so there is no trade ban applicable to products or services which are underpinning Palestinian activities in the West Bank, exactly for
but these are Jewish-owned businesses, which you're targeting. You're targeting Jewish-owned businesses. These employ Palestinian Arabs.
We're not targeting Jewish organizations or businesses or enterprises. We're targeting settlements. We're targeting enterprises.
What does that mean?
And individuals who are not respecting Palestinian sovereignty. This is not very complicated.
There is no Palestinian sovereignty. You talk about
again,
settlement
if you
businesses.
deny that there is Palestinian sovereignty on the West Bank, I have to be clear about this.
But the Oslo Accords make it clear that there isn't.
Palestine has sovereignty on the West Bank. That sovereignty is being undermined by Israel, predominantly through these settlements. And that's exactly why. In fact, you're highlighting why we're pushing back on these settlements. They are hindering Palestine from being able to implement its sovereignty. And that's why we're so clear-eyed about this, and that's why we're determined to put this forward.
You don't seem to understand the point that I'm making, though. These are businesses that you call settlement businesses. That just means that they're Israeli-owned businesses operating in the vicinity of Jewish communities in the area.
They're Israeli settlements.
And they employ, look, before the 7th of October, for good reason, it was even higher, 48,000 was the estimate then. Unfortunately, many of those work permits couldn't be renewed because the fact is that Arab-Palestinian workers were gaining intelligence, were gathering information that assisted in the massacre the 7th of October. But the fact of the matter is, if Norwegians and the Norwegian government really care about the prosperity of Palestinians in the area, the ability of the Palestinian economy to continue to grow, then what on earth are these tens of thousands of Arabs being employed in Israeli-run businesses in these territories and the hundreds of thousands that are dependent on those jobs when you think about their family dependents? What are they going to do as a result of becoming unemployed?
This is a valid question. I'm glad we're having this discussion. I think that's a valid point and a fair inquiry. So just to be clear, in terms of the law that has been drafted, it has a explicit carve out for Palestinians in the law. So that has been dealt with in terms of what we're putting forward. We'll see how that goes in terms of the consultation, which is now transpiring, but this has been dealt with. But I just want to make...
Are you saying that any Israeli business that employs Palestinians will not be boycotted?
When you're asking a question, I have to be allowed to respond.
I need to clarify that point. Forgive me. That's a very important point. Are you saying that any Israeli business that employs Arab Palestinians will not be subject to the boycott?
When you speak, I'll let you speak. And then it's important for me to be able to speak without...
Yes, of course. Please answer the question.
What I'm trying to say is, I think that there is a narrative out there, which I think some listeners, viewers might subscribe to, that, this is all perfect. This is all nice and well. You have Israeli enterprises and they're employing tens of thousands of Palestinians and, predominantly they are satisfied with how things are going. This is not the reality for most Palestinians on the ground in the West Bank.
How do you know that?
They are subjected to violence, repeated violence, house evictions, demolitions, violence, perpetual violence. There is zero accountability. This is not also, and this has been my point also when I've been on this podcast on previous occasions. This is a clear violation of international law, a clear violation of international humanitarian law and human rights law. But it's also not productive for Israel. Israel is now evolving into a pariah state internationally because of these activities. Now, you can sit and advocate that these are sound policies, and this is based on international legal norms, but they're not, and they're hurting Israel. And we're saying we're a friend of Israel, and that's why we're pushing back on these activities.
Kravik, can you please answer the question? Are you saying that if Israeli-run businesses, that if Israeli-run businesses employ Arab Palestinians, they will be exempt from this trade ban? That was the implication of what you said.
I'm saying that there is a carve out in the law, but this is still being discussed. So we'll see how
Is that the
where we
intention of the
end up.
ministry?
But there is
Is,
a carve out in the law exactly for the reasons that you highlighted. Lots of Palestinians, for given the fact that there is no other alternative for many of them, have been working on the settlements, and they have an income that is derived from some of these settlement activities, and there is a carve out to ensure that Palestinians are not hurt by what we're putting forward. Yes, there
how
it
on
is. So we'll
earth are
see
you
how
going to
this will be
enforce that?
formulated at the end of the consultation. But this is what we're trying to achieve, and that's exactly to respond to the inquiry that you put forward. But I think, Henrik, you had a question now.
Yeah, Andreas, a final question because I know we're running out of time. How will Norwegian authorities reliably distinguish goods produced in settlements from goods produced elsewhere in Israel, especially when, the supply chains and labeling are complex? Like, what about a Palestinian with an Israeli passport? Would goods he produces be illegal under this ban?
Well, I think this is something that have to be dealt with by the prosecutors, by the police, as is the case for most of our sanction regimes. You have various questions that can be difficult. But if you look at all sanctions regimes that we are aligned with, and there are many. We have sanctions applicable to Iran, to Russia, to Hamas, to other kinds of nefarious governments and movements. It's up to the prosecutors to ensure that they're operating on the basis of the applicable evidentiary standard, which is, of course, proven beyond reasonable doubt. And that will apply here. So if there is doubt, obviously individuals and enterprises can't be prosecuted. But what the law is looking at, again, is for Norwegian businesses and enterprises, individuals, not to support these settlements, which are illegal under international law. And I'll grant you that there can be difficulties in terms of ascertaining the facts on the ground, but that will have to be dealt with. And if there is doubt, then obviously no one should be prosecuted.
Natasha, a final point before we have to end.
Well, it's extraordinary, and it should not be lost that these proposals include criminal sanction within Norway. The idea that a framework would be put forward that is so nebulous, so unclear, where basic questions of what is actually targeted by this legislation cannot be answered, that would lead to potential criminal liability is nothing short of extraordinary, and it should worry every Norwegian citizen, and indeed it has extraterritorial applicability on the current proposal, so it should worry others also. I can't see anyone wanting to conduct business with Norway in these circumstances, and unfortunately the inability to answer partially produced goods in businesses adjacent to settlements. There's no such thing as settlement businesses. These are private entities that are operating in these areas that employ lots of people from the local communities, including Jews, Arabs, Christians. The idea that there would be a distinction based on the ethnicity of employees or business owners, that's also unclear, is morally reprehensible. And the fact that so many would be led by what can only appears to me to be blind hatred for the Jewish population in these areas to embark upon enterprises of this nature, which are so confused, so incoherent, and so contrary to existing international legal frameworks, is mind-boggling. If it passes as the minister seems confident it will be, I'm sure there will be consequences, very negative ones, for the local population in the area, Jews and Arabs alike, and no doubt for Norwegians as well.
All right, I'll just end on one point. The rhetoric is pretty harsh in terms of the blind hatred and other analogous expressions directed against the proposal. The support or the feedback thus far has been relatively positive. So again, we're pretty confident that this will go through, and that other countries will align themselves, putting forward similar legislation in due course. Obviously, that remains to be seen, but that's the signals that we're getting. And I should just state that we have no um, problem with Israel as a state. In fact, we're supportive of Israel. We support the Jewish population. We support trade with Israel, but we're not going to support trading with settlements and settlers, which under international law are illegal. And I should just say, in terms of this issue of criminality, etc., all our sanctions, all restrictive measures under international or under Norwegian domestic law are sanctioned by way of criminal measures. So this is in line with our standard practice when it comes to these things. And I'll admit, and this is the case not just for this regime, but for other regimes also, there can be issues of interpretation that can be difficult. And it's not for me as a representative of the Norwegian Ministry of Foreign Affairs to respond to that. That's for the police to respond to. This is, again, this goes back to how we are organized as a state that abides to international legal safeguards. I can't comment on the actual interpretation of the law because this, again, will be decided on and ascertained by the police.
The police are now the experts you're relying on in international law?
I just need to, at this point, I just need to thank you for a wonderful discussion. I appreciate the positions put forward, and hopefully we can do this again at some point.
Yes, thank you so much, Natasha Hausdorff and Andreas Kravik, for joining us today. Thank you.
All
Thanks,
right.
Henrik.
Thank you.